Did you know? Nationality Act of 1790. 1790. Resources. National Archives. Marion L. Smith on Race, Nationality, and Reality in U.S. Immigration Law. https://www.archives.gov/publications. Prologue 2002, Sumi R. Imig Radio NL A1.html. PBS. Race Timeline. http://www.pbs.org/raki000_about 002_03_DGO deeper.htm. This was the first law to define eligibility for CITIZENSHIPBYNATURALIZATION and establish standards and procedures by which immigrants became U.S. citizens. In this early version, Congress limited this important right to free white persons. Nationality Act of 1790. Immigration History. Summary. Discussion questions. T. May. Congress first defined eligibility for citizenship by naturalization in this law, and limited this important right to free white persons. In practice, only white, male property owners could naturalize and acquire the status of citizens, whereas women, non-white persons, and indentured servants could not. Access to citizenship would become more expansive over time, although the racial restriction was not eliminated entirely until 1952. This law produced the legal category of aliens ineligible for citizenship, which largely affected Asian immigrants and limited their rights as non-citizens to key realms of life in the United States such as property ownership, representation in courts, public employment, and voting. After Congress passed the Nationality Act of 1790, who could become a citizen? THROUGHNATURALIZATIONAND. What did eligible immigrants have to do to gain citizenship rights? Who would have been excluded from citizenship through naturalization under the Nationality Act of 1790? How might access or lack of FACCESSTONATURALIZATION and citizenship rights have impacted different immigrant communities over? So URCE. UNITEDSTATESCONGRESS. ANACTTOESTABLISHANUNIFORMRULEOF 1-7-9-0. MARCH 26. Be it enacted by the Senate and House of Representatives of the United States of America, in Congress assembled, that any alien being a free white person, who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years, may be admitted to become a citizen thereof on application to any common law court of record in any one of the states wherein he shall have resided for the term of 1 year at least, and making proof to the satisfaction of such court that he is a person of good character, and taking the oath or affirmation prescribed by law to support the Constitution of the United States, which oath or affirmation such court shall administer, and the clerk of such court shall record such application, and the proceedings thereon, and thereupon such person shall be considered as a citizen of the United States. And the children of such person so naturalized, dwelling within the United States, being under the age of 21 years at the time of such naturalization, shall also be considered as citizens of the United States. And the children of citizens of the United States that may be born beyond sea, or out of the limits of the United States, shall be considered as natural-born citizens, provided that the right of citizenship shall not descend to persons whose fathers have never been resident in the United States. NATURALIZATION. Race, Nationality, and Reality. IN's administration of racial provisions in U.S. Immigration and Nationality Law since 1898. Summer 2002, Volume 34, Number 2. In recent years, scholars, scientists, and policymakers have turned increasing attention to matters of race as a factor in our society, the judicial system, and in American history. The history of U.S. immigration and nationality law demonstrates how race became a factor in determining who could come to America and who could not. Studies of Chinese exclusion laws are the old immigration, quote the Dictionary of Races or Peoples, system, trace a tradition of racist immigration policy. prepared in 1911, was used by INS. The Supreme Court reinforced this policy in the 1920s so issues until the early 1950s. INS with a decision stating that Americans shared a common understanding of who was and was not white, and by extension shared a common understanding of who did and did not belong in the United States. Despite Supreme Court pronouncements, federal officials charged with administration of U.S. immigration and nationality laws were keenly aware that not all Americans shared the same understanding at any given time. More important, any common understanding of race or ethnicity shared by a majority of American society evolved over time, while the law remained locked in 18th-century language. For officers of the Immigration and Naturalization Service and its predecessor agencies, issues and problems of race were more practical than theoretical. Immigration laws barred the entry of the poor and sick, and Ellis Island immigrant inspectors could check to see that. By Marion L. Smith. Arriving immigrants had adequate money while public health service physicians checked the immigrants' health. But how did they decide who was or was not white? What rules did they follow? How could those rules be changed? When Congress finally eliminated the racial provisions in U.S. immigration and nationality law in the 1940s and 1950s, generations of federal practice and procedure did not instantly disappear without a trace. Over the years, other government agencies had developed their own racial classification systems, partially borrowed from INS experience, and such systems could take on lives of their own. Thus a review of how INS officials met the challenge of interpreting racial provisions in the law, and how the courts, Congress, and an activist public helped shape that interpretation, is necessary to fully appreciate current debates over race. It may also be helpful in determining whether we share any common understanding on such matters today. 1790, and throughout the 19th century, Congress legislated separately regarding immigration and nationality. One congressional committee drawed nationality law, defining U.S. citizenship and how it might be lost or gained. Another committee addressed immigration issues and only began serious attempts to govern or regulate immigration as the 19th century came to a close. With the exception of the Chinese Exclusion Act of 1882, the two bodies of immigration and nationality law were not coordinated, nor did either make any reference to the other. During the antebellum years and for a time thereafter, immigration and nationality law appeared to agree and serve national goals. The United States achieved a policy of free and open immigration largely by failing to legislate on the subject. The Steerage Act of 1819 remains Congress's most aggressive action regarding immigration prior to 1875, and the 1819 law worked to encourage immigration by ensuring safe and healthy conditions aboard passenger ships. 1 As the nation marched west, a regular supply of immigrants from Europe arrived to occupy new territories and hold them for their new nation. Nationality law allowed for political inclusion of new arrivals into the United States. Between 1790 and 1802, Congress established simple rules for naturalization and facilitated the process by granting naturalization authority, which belonged originally to the legislative branch, to any court of record. Two naturalization requirements included 5 years residence in the country, good moral character, and that applicants be free white persons. Such language in 1802 preserved the constitutional understanding of citizens as white persons and exclusion of African Americans and Indians not taxed from citizenship. U.S. nationality law generally transformed Northern and Western European immigrants into U.S. citizens. For most of the 19th century, Europe was the primary source of immigration to the United States, and it no doubt seemed the law would be adequate forever. The 14th Amendment declared all persons born within the United States to be U.S. citizens and worked to bestow citizenship on freedmen. Congress went further by amending naturalization requirements in 1870 and extending naturalization eligibility to aliens being free white persons, and to aliens of African nativity and to persons of African descent. 3. The 1870 revision of Section 2169, U.S. Revised Statutes, laid the foundation for future confusion over racial eligibility to citizenship. The rule did not state that white persons and black persons may naturalize, nor did it limit naturalization to those of European or African nativity or descent. Rather, the 1870 rule appeared to apply a color test. White persons and those with African origins, i.e., black, but did so by reference to geography. Extending naturalization to blacks as Africans in 1870, Congress banned the naturalization of Chinese in 1882. The Chinese Exclusion Act of that year, which is primarily an immigration law, included a section directing that no state court or court of the United States shall admit Chinese to citizenship, and all laws in conflict with this act are hereby repealed. For the 1882 law clearly directed the courts not to naturalize any Chinese, but it did not explain whether Chinese indicated race or nationality. There was relatively little controversy or litigation surrounding racial qualifications for citizenship before the late 19th century. As others have explained, federal citizenship was of secondary importance to state citizenship until sometime the Civil War. 5 Yet as sources of American immigration and increasing numbers of people came from southern and eastern Europe, the subcontinent, and Asia, their desire to naturalize confronted the racial limitations in U.S. nationality law. Because naturalization remained a judicial function, the courts were left to decide who was or was not a white person, or an alien of African nativity, or person of African descent. In this question, as in all naturalization matters, the courts had little guidance. The delegation of naturalization authority to any court of record in 1790 led to a motley array of more than 5,000 high and low courts exercising such jurisdiction by the turn of the 20th century. Case law was their only guide, for there was no central or national authority to answer judges' questions regarding the finer points of naturalization law or procedure. Methods adopted by late 19th century courts to determine qualifications for citizenship varied widely. Just as courts in some localities interpreted the good moral character requirement de-errantly, judges in de-errant jurisdictions had de-erring ideas of what constituted whiteness. Many thousands of elected county judges across the nation simply relied on their common understanding of race, an understanding presumably shared by the local community. It was the lack of uniformity among naturalization courts and procedure, and the fraud it bred, that underlay Congress's establishment of the U.S. Naturalization Service by the Basic Naturalization Act of 1906, 34 Stat. 596. The law placed the Bureau of Immigration and Naturalization in charge of all matters concerning the naturalization of aliens, with the general purpose of promoting uniform naturalization practices nationwide. While this seemed a clear mission, Bureau officers would soon learn that influencing the courts, especially non-federal courts, presented a persistent obstacle. Furthermore, inconsistencies within nationality law would prove difficult to reconcile. Among the most difficult was the issue of racial eligibility to citizenship. As the Bureau began its work, it found racial eligibility already a complicated subject. Though Section 2169 contained the broad rule regarding white persons and persons of African descent, an Act of April 9, 1866, and the 14th Amendment to the Constitution decided, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are declared to be citizens of the United States. In 1898 the Supreme Court confirmed that the amendment applied to the U.S.-born children of Chinese and to others prohibited by law from becoming naturalized. 6 Thus Section 2169 set racial qualifications for naturalization only, it did not apply to citizenship conferred by birth. Congress also, at times, ignored Section 2169 and used its original authority over naturalization to extend U.S. citizenship to groups of racially ineligible aliens. Numerous Native Americans were naturalized by treaty during the 19th century, as were Chinese-born citizens of Hawaii at the time of annexation. 7. The 1906 naturalization law retained Section 2169 limiting racial eligibility to citizenship, but as noted above, that language was not clear. By mixing references to color and geographic origin, the law displayed a then popular confusion, or equation, of race with nationality. And if the vague language used to convey congressional intent regarding race was frustrating to federal naturalization officials at the turn of the century, the problem only worsened as time passed. Racial theory and terminology evolved each decade. Racial understanding associated with the eugenics movement was largely if not completely discredited after World War II, yet Section 2169 remained the nationality law of the land. Even when amended by Congress, the addition of equally vague language regarding additional races only served to increase naturalization service difficulties in administering the law. While naturalization officials fielded questions about whether the term race meant color or nationality after 1906, they also encountered a third use of the term by immigration officials who operated within the same bureau. The U.S. Immigration Service developed its own conception of race during the late 1890s in an effort to improve immigration statistics at the Port of New York. Ellis Island officials created a list of races or peoples with which to classify arrivals at that immigration station. The list of races was expressly not intended to be an ethnological classification, nor was it to be a history of an immigrant's antecedents. Rather, it was considered a practical tool devised by immigration officers. Familiar with the growing flow of immigrants into the United States, a tool that grouped together people who maintain recognized communities. Statistics concerning such recognizable groups were deemed valuable as predictors of where such immigrants might settle and what occupations they would follow. An immigrant's race or people decided these questions because, as one of its authors explained, an immigrant is bound to ally himself with people of his own language already here and will enter the pursuits in which these people have found they can succeed. 8. Immigration officials, and their list of races or peoples, employed the term race, as we might use the term ethnicity. Yet even among Ellis Island immigration officers, experts in identifying an immigrant's origin by his language or dress, common understanding was not universal. Rather, inspectors were as apt as the general public to use the terms race and nationality synonymously. Victor Saw-Ord, a medical doctor at Ellis Island and one author of the list of races or peoples, admitted there were errant ideas as to what these statistics are intended to show. As an experiment, he asked errant immigrant inspectors to classify the same immigration passenger manifest record and found confusion as to nationality, race and residence, and a lack of agreement as to the territorial limits of the districts specified. 9. For the moment, the relation of race to ethnicity or nationality was an academic question for Saw-Ord and the Immigration Service. Immigration law contained no reference to race beyond the exclusion of Chinese. When Congress did insert the word race into the Immigration Act of 1903, the purpose was to extend application of the list of races or peoples statistical scheme to all U.S. ports of entry. 10. Until Congress instituted the national origins system of racial quotas in 1924, the race question remained primarily a headache for the Naturalization Service. As noted above, when the service began its work in 1906, the courts had not come to a clear definition of who was or was not a white person. The very existence of the Naturalization Division within the Bureau of Immigration and Naturalization, however, grew from Congress's mandate that it oversee and guide naturalization work by the courts. Naturally, those with questions about naturalization addressed them to the division. The clerk of the U.S. District Court in St. Louis, for example, asked in early 1907 whether the term white person, in Section 2169 in the statutes and in the Division's Naturalization Regulation 21 designated only those whose color is actually white, or does it further include all persons of what is ethnologically known as the white or Caucasian race? 11. Whether to apply a color test, or to determine whiteness by reference to an ethnological table of the families and races of mankind was the basic question put to naturalization officials for years thereafter. Court officers, attorneys, and private citizens regularly requested a ruling from the Department of Commerce and Labor on the question. But, as guidepost to continue reading, https://www.archives.gov/publications/prologue/2002/summer/immigration-law-1. Hope you enjoyed the information. I'm only a guidepost to information, then I share. I take you to my sources. Nothing more, nothing less. I love law and like to follow it.